Let's go ahead and get started. I'm pleased to call to order meeting number 67, public meeting number 67 of the Massachusetts Gaming Commission on Thursday, May 16th, starting today at 9:30 in the morning rather than 1 o'clock. The first item on the agenda was an appeal from one of the applicants that we were going to hear on, I guess, some issue of redactions, questions about redactions, but I'm advised by our general counsel that that has probably been resolved, so we're not going to have a hearing after all. So we will move right on to number 3, which is approval of the minutes. Secretary McHugh.
The minutes have been distributed. And I have no comment on the content. They're there for whatever comments anybody would like to make. But I would note that Artem Shadatnov, one of our counsel here, has finally integrated all three aspects of our meeting record keeping: the minutes, the transcript, and the tape. And I think this is a terrific way to proceed. Will help everybody both find in the transcript the parts of the transcript they're interested in, and will also allow people to go directly to the place in the tape that is also posted online to look live at the proceedings, or the part of the proceedings they're interested in. In addition to that, he's developed a mechanism that allows him to do this in less time than it was taking to prepare the other minutes. So we have picked up both person time and produced a better product, and I think it's terrific that he's done it this way. So.
Yeah, I agree. Please thank Artem for us.
Excellent work.
Any comments on it, on the minutes?
I do, and I concur with integration. I do want to note on page 4 that this may be a typographical but important change, where it says evaluation process 10:18 a.m. Commissioners McHugh, Stebbins, and Zuniga have been researching the different ways other organizations conduct evaluations. It's perhaps Commissioner Stebbins and McHugh, not Zuniga.
Right. Yeah, I think actually that's a substantive catch, I think. That's good.
I have a second question, or actually a comment. In the time frame that's here in between 10:26 and 11:18, there was discussion that's correctly summarized here, but I think there's that important point that is omitted from this summary. It's of course in the transcript, so that's great, but I would like to highlight it in these minutes because not everybody will go through the transcript. And that's a point I made relative to making sure that important roles in the decision-making and management of this evaluating process are not delegated out to an outside party. And I believe there was a little bit of consensus in that, to that effect, but if there could be a reflection of that in these summary minutes, I would appreciate that.
Either staff or outside parties.
That's right. Well, no, we did talk.
I made both points, I think.
Both points, yeah.
I think that's a good construction. That's a good suggestion.
Yeah. You know, that one summary point, it will be reflected in the transcript, of course, but I would like it inserted here.
Well, what is the, do you have, that is an important point. So do you have some suggested language there that we can all agree on?
Sure, that I made the point that we should not delegate important roles, notably in the decision-making, out to an outside party.
Or to staff.
Yeah,
Would you be okay? I think it was both things that were talked about.
It was both. I was most concerned about an outside party and an advisor that then
Right.
has a role in the decision-making, and I'm talking about a significant role.
Right.
That's what we want to preclude, or what I want to preclude.
All right, so this is a comment that you made, not a decision that the commission made.
It's a comment I made, but I recall there was some agreement, notably by Commissioner Cameron.
Yeah, I don't think there's any disagreement with the principle. It's the,
Right.
and I don't have the transcript fresh in my mind, it's the question of what is, where's the dividing line between what's permissible for staff to make decisions about and what's not?
Yeah,
I mean,
and that wasn't included, of course, and I guess that'll be the subject of ongoing discussions, but it's that principle that I wanted to just be reflected.
So, Commissioner Zuniga, with assent, with concurrence by other commissioners, said that we have to ensure that decision-making by staff or outside parties on important matters is not delegated to outside parties or staff on important matters, that are obviously to be defined later.
And I think the point of this was not that we doubted that, we knew that, but we wanted to make sure the outside world knew that. There was some concern that maybe we were
Right.
over-delegating.
Right.
And we absolutely not. I think we've been absolutely explicit and foursquare about that, but we were concerned about making that point to the outside world.
Okay.
Good.
Thank you.
Thank you. Anything else? You want to move?
So with that change, the change in the 1018 and the 1026 summaries of what occurred, I would recommend, I would move that the minutes of the May 3rd meeting be approved.
Second. All in favor?
Aye.
Opposed? Ayes have it, unanimously. I'm going to suggest just a one thing. There are two items, the racing items and the research item, numbers 8 and 9. Actually 10 as well, because it turns out there is a last-minute item of business, 8, 9, and 10. That we do those before we start, number 7, before we start the reg review. We may not be, the research, Rachel Volberg won't be here until after lunch, so we can do her whenever she gets here. But I think the review of the regs is the one that could run on and on and on. And I wouldn't want to run the risk of not getting to 8, 9, and 10. So if everybody's okay with that, I'm just going to rearrange that schedule. Is that all right?
Fine.
Okay. So I assume you're here. Yeah, okay. All right, so let's go to item 4, Executive Director Day. Good morning.
Good morning, Chairman Crosby, members of the commission.
Good morning, Executive
I think I'm
Director
going
Day.
to see if I can change this to start with. Oop, wrong change. Just thought rather I'd start out making sure that change was taking place instead of experimenting with it later. One thing, Chairman Crosby, I'd like to thank Janice for her assistance and the extra conveniences and the time that it took.
I was meant to say the same thing. I mean, wherever she went, we've dressed this place up a little bit. Looks a little.
Can't show the world.
Yeah. Right. I love the nameplates and the tablecloths. I can take my shoes off now. No, it's great. Thank you. Looks much better. And it was actually Executive Director Day's idea.
You might
It's a
know,
good
though.
idea.
Right.
You might know,
It looks like we might be here, I mean, permanently.
Yeah.
We'll let you know if we know.
Yike. Okay.
With that, I'd also like to just briefly introduce just a couple things going on the general administration side. We've got beginning to interview candidates for the Director of Licensing, which we're really excited about, and we're waiting for background on finalists for the Directors of Workforce Supplier Development and Research and Problem Gambling, and we will be identifying candidates for Chief Information Officer for interviews hopefully next week.
And CFAO?
CFAO is still with an executive search firm, and they're giving us some assistance to identify candidates that will work for us.
Okay. So it's a little bit behind a CIO, apparently.
A little bit, just partially because we have asked for help from an executive search firm.
Okay.
Also, I'd like to note that as this is, of course, our first attempt at a regular monthly meeting, or bi-monthly meeting, or twice monthly, how's that? About twice monthly meeting, and all the coordination and the change of process and everybody's patience with that are appreciated, and the staff have been real great about getting things ready and in the packets. So thank you very much. Also, it's about my 2-month anniversary.
Wow.
Short a couple days, but.
Congratulations.
But with that, I just wanted to let you know that I've completed personal individual meetings with each member of the staff and an orientation discussion. It was very beneficial and enjoyable for me. We have a great group of people on the commission, which I think you already were aware of that, but it was nice to have a chance to talk with each of them. I've also set meetings with the directors and with each of the commissioners. I've also had a opportunity to meet the commission staff at Plain Ridge and Suffolk Downs, and an additional opportunity to meet with the Attorney General, the Comptroller, the Budget Director, and their staffs. And that's been very informational for me as I'm trying to get my feet on the ground. In addition, which I wanted to take a minute, is the applicants have sent representatives to headquarters office and to meet with me, introduce themselves, and it's always helpful, besides talking about applications, to know some of the faces behind those applications, and I just wanted the applicants as well to know I appreciate their time and effort and their interest in Massachusetts in these projects.
And during the same 60-day period, if I'm not mistaken, you packed up and sold one house and found a new one to move into.
That's correct,
Right.
yes.
Could you please get to work, you just.
Other items, fortunately, I was close to the job location, so that part, I didn't have to do much commuting at this time.
Right.
With that, unless there are questions about any of those topics or any others that commissions might have, I'll move on to the public comment section. I think it was last commission meeting, we had a brief discussion. I'd raised the question about whether it would be appropriate to include a regular time for public comment in the agenda. And the suggestion was, Chairman, I believe from you, that we pose that question for commission discussion. During that time, Commissioner Stebbins has been kind enough to identify for me a document, a memorandum that he produced about various public comment issues, but it happened to include an item that had come before the commission. I don't think Commissioner Stebbins was confident if it came before and was approved or discussed. It had been a little while. So with that, I thought that it does speak about a public comment period, and I thought it might be appropriate to start the discussion with that particular language. It's in your packet, and it looks like this. There's a section which says MGC public speak out sessions. And I don't want to bore the commission, but for the folks in the audience, I just thought it might be good just to run through. It's a very short paragraph. That the MGC will allow an opportunity for citizens and residents to address the commission during a regular business meeting. 30 minutes would be set aside each month prior to the start of one of the commission's regularly scheduled business meetings. Interested citizens would need to sign up with the MGC office by close of business day before the meeting. Speakers are called by the chairman to speak in order when they are registered. Each speaker would be limited to 3 minutes each, though the chair has authority to limit the amount of time in order to accommodate all those who registered. A resident may also submit comments at that time in written form. Comments will only be directed to the commission and not include a discussion about other commission officials. So with this, I thought it'd be a way to begin discussion on whether this is this description would work for the commission to continue. We wanted to modify it by changing the sign-up process at all, or before the meeting or after the meeting. But I thought this would at least give us a chance to start the discussion.
Great. Commissioner Stebbins, I didn't realize this was written a year ago. I thought you just did it, which was impressive. But do you want to comment on that? Did you have then, or do you have now a strong feeling?
No, this was a model I pulled off of a system we had used with respect to the Springfield City Council. And for topics that anybody wished to raise, they could address it to the to members of the council prior to the start of our regular meeting. But to make sure that if somebody signed up, we can make sure that they were afforded time to speak if they had gone through that step. But certainly, I'm open to revisions for it to make sure that it best suits our needs.
Was it just about anything? So that somebody could come before the city council and just talk about anything, whatever?
Yes.
Yeah.
I'm curious, of course, then the meeting would effectively start half an hour or an hour earlier.
Correct.
There's a first item in the agenda. It's not as if anybody can come talk before the meeting convenes.
Well, we can do it whenever, yeah. The threshold question is whether we think adding something like this as a matter of course is good idea, and adds something to our participatory, transparent, and fair aspiration. And I must say, I'm not sold that it does, but so let's talk about it. If we decide that it is, that it does add something, then we can figure out how to do it. But what does everybody think about the idea in the abstract?
I think opportunities to speak are usually a good thing. I would be interested in Director Day. Did you have something like this in your previous experience, and did it work well?
The answer to both that is yes and yes, but there are potential difficulties in that whole process, because overall I would evaluate it as a successful means to make sure if there are those who have issues that they want to just address the commission about, are able to come forward and do that. On the other hand, there were some issues that I'd classify as odd for purposes of this discussion. But
diplomatic.
the other side of it is overall, the amount of folks that came during that period usually occurred if there was a particular issue that people or businesses had felt needed to be brought to the commission. It was not overused, I didn't find that. But it was also toward the end of the meeting, which is a little different, did not have a sign-up process involved. From my perspective, before or after, it's more, as the chair has mentioned, the concept if you want to have that opportunity for the public to pipe in with comments at some point. And I think it is a good process to have at least a sign-up for those comments in the back to assist the chairman, if nothing else, to make sure that people are identified and have the opportunity to come up if they want to talk. But there are pros and cons. I completely understand that. And the times that I've seen it used is, of course, there wasn't video streaming and all those different opportunities as well. So it's some of those things weren't available.
I think of two aspects to this. Is it of benefit to the substantive benefit?
Just one second, excuse me, just one second. Are we streaming? Does anybody? Rob, are we streaming?
We're still working on it.
Can we put something on the website that says that, okay, if there isn't, okay, thanks, sorry.
Looking at it from the commission's standpoint, does this process yield substantive information that would be helpful to us? And what's the likelihood of that? From the public standpoint, does it provide a addition, symbolically at least, to our determination to be transparent? It probably does the latter. It probably doesn't yield a lot on the former side. And I do think it's important to hear what the public has to say. But certainly we've been rigorous about reading and replying to things that are sent to us by email. And I think the processes we're going to discuss later on today will have substantial opportunities for the public to talk about specific topics in the licensing process. And I think we ought to also be aware of other opportunities as we move down the line to reach out to the public, to invite people to come in and talk about various topics. The decision to make those invitations could be triggered by emails that we get and a volume of concern about a particular topic. But I think that the likelihood of repetitive, narrow-focused comments in an open forum is high, and I don't think the addition to our transparency would be high, and I don't think the yield informationally to us would be high, and so I would be reluctant to do this.
I would agree with that, and I would emphasize that we have, in my estimation, we have been very successful requesting and obtaining written comments whenever there is a particular topic that we want to hear about. And we have heard a lot about it recently, of course, but this has been an ongoing process all the way back from the start. So that part is working, in my view, is working rather well.
I come down the same place. You said it exactly right from my standpoint. Commissioner, you feel strongly,
No.
You're laying it out there as an idea, not necessarily as an advocate for the idea?
No, it's, I think at the time we were trying to, this is certainly, prior to us having an ombudsman who was out there talking with people in the community, talking with applicants. I think probably what was missing, gets to Commissioner McHugh's point, that we would want to direct people that wanted to come and express an opinion at a public meeting, as long as it was based on an item on the agenda that we were considering that day. So the opportunity to go before the meeting started would have a little bit more prevalence and importance than just come up and talk about a general topic, but kind of keeping a member of the public's comments directed to an agenda item for that day.
All right, well, it sounds like we have a consensus probably. For the time being, then let's not do this. Let's stick with what we've got. And it will always be open-minded to thinking about changing as we go along, but for the time being, I guess we'll go ahead as we are.
That works, and then be helpful as we continue to work on the agendas. With that, I will move on to the evaluation plan, if that's acceptable. I've been looking forward to talking about this because we've been doing, of course, Commissioner Stebbins and Commissioner McHugh and I have been working to prepare a proposal for the commission, especially since our last meeting, and they have been working on it before that, trying to identify sources of information and resources for the commission. What I'd like to do is, you have in your packet all the scribbling on it, you have the diagram, and what I'll do, if it'll work for the commissioners, since we are getting close on June 13th to the suitability determinations relative to the slots license category 2. And from there, we'll be accepting applications, which leads us to a period of evaluation and award of licenses. So category 2 will actually provide us the ability to look at this timetable and then also look at it relative to the category 1 timetable as well. That's why and if there's a lot of timetable questions, I know Commissioner Zuniga has helped support efforts in that way, and he's available, and he's got it up on the screen now. And as we talk, under category 2, you can see the evaluation timeline here shows 72 days right now, but I'll try to put that in a little more perspective.
Do you have this in the machine?
No, that's not in the machine.
All right, that's interesting for those folks to
Yes.
see it. Yeah.
Let me, I'll just go ahead and start and
Yeah.
provide a brief explanation of what the chair has commented upon, and then ask if Commissioner Stebbins and Commissioner McHugh have additional items. So let me start. What we are looking at is anticipating the receipt of applications that come into the commission for the Category 2 or slots licenses. As those applications come in, they will come into a licensing team. That licensing team will be directed by our Director of Licensing. The concept of that licensing team will be to actually take the documents and review them for completeness in effect. So it's a pretty straightforward opportunity, but it won't be at all unusual for applications to come in with some parts incomplete or unanswered. We can anticipate that. As that takes place, they will then just go through a process of notifying the applicants and asking for the additional information or clarification. They'll take the application information and break it down per category. And so as this document appears to you, of course, the categories we'll be talking about over and over again are from the matrix, the evaluation matrix that the commission has already developed. So the licensing team breaks down that information per category. There are 5 categories, moves that to the evaluation teams. And I'll come back to the evaluation teams here in a minute. But after that process has taken place, we're guesstimating that the licensing group probably about 7 days from receipt of application. After that information goes forward to the 5 category teams, we would propose that then we'd actually have an introductory public meeting. In that process, each applicant would be allowed about an hour, that's up to the commission ultimately, to give an overview of their application, which helps bring in perspective what they see in the applications, what their proposal is, but it's not intended to be any extensive, detailed rendition. It's supposed to be an overview from each applicant, and at that point allows the category teams and the commissioners to have that perspective when they proceed with the information. The proposal also does set up 5 evaluation teams. The information would go from licensing according to the matrix category, would come to the evaluation teams. Each team would receive the information relative to their topic. The teams are, of course, overview and general, financial, economic development, building and site design, and mitigation. And this basically comes right from our current matrix. Each one of those groups, estimating, would recommend probably no more than 5 individuals on that. On those groups, we're recommending that those consist of a commissioner as a chair, would chair each one of those groups, probably a staff member on each one of those groups, most likely be a consultant expert on each one of those groups. Then interested parties could, it also could be a good idea, possibly we can borrow some expertise from another state agency for the purpose of evaluating these proposals, and add someone with additional expertise specific to that area. What it does, you might note, is it shows advisory groups. So a lot of these areas are extremely complex and have technical information, whether it's building design, environmental protection. The idea would be, and I know Commissioners McHugh and Stebbins are in the process of identifying expert advisory or expert resources that could advise the commission. So the concept might be a firm has an individual that sits on the one of the 5 teams, financial, for instance, and some of the details may be specific to audit or economic forecast, is not particularly expert with that one area and would be able to refer back to the resources identified that support that individual and get specific information for the group to consider around that topic and bring it back to the category team. So that the idea also has a project coordinator. The project coordinator would help select these advisory group individuals and would also participate in those category groups and assist with keeping the process moving forward, providing expertise, ensuring that discussion, if there's areas that doesn't seem to be under discussion by the particular experts there, to make sure that that information comes forward, and then would also serve a function to report to me about how the process is moving forward and what's ultimately.
And would that be those would be staff people on our staff, the project coordinators?
No, the project coordinator would be a contract as well.
Oh, okay.
So you basically have a project coordinator that is helping with the overall the process moving forward, not the decision-making about the evaluations itself.
Right.
The process moving forward, and then can also interface with the various expertises that the commission decides to involve in the process.
So these would be content-specific people from each of these, with expertise in each of these 5 areas?
The advisory groups that's what they would consist of, and then the project coordinator would have, part of the expertise would be familiarity with coordinating projects,
Yeah.
but also, I think the thought process is that individual would have some of the expertises that we're looking at, so that they have some particular knowledge, might be design,
Right.
so they have some knowledge to directly put forth. And then it gives them a familiarity that the rest of the category team may not have, that helps them to make sure the information is being considered along the way. The category teams would be responsible for developing comparative ratings and findings, or a factual statement about each one of the provisions in the matrix itself. That rating could be good, better, best. That's probably works just as good as anything else, but there might be another possible way to express it. Along with that, the team would develop factual statements that support that rating. So the product is factual statements and ratings. And the idea here, in addition, is that what would happen is during the period of time that the 5 teams, the evaluation teams, have the application information, are working on coming up with the ratings, the commission would hold public input meetings in the various areas, not wait for the host public hearing, but actually initiate a process. And the consideration is not the entire commission, but probably 1 or 2 commissioners would identify probably surrounding community areas and actually go out and listen to comments, not a decision-making hearing at all, and bring that information back that would be available to these teams. One of the products that the teams would have would be before the host community agreements. The idea would be that the teams would generate questions or supplemental information, interest that they had that wasn't included. Those questions and information would go to the commissioners. The commissioners would then, of course, have the opportunity to ask those questions, request additional information if all of you thought it was relevant. If not, you would obviously decide not to do that as well, but at least those questions would be available. Once then the host community agreements hearings were completed, the team would then get back together and produce comparative ratings and those factual statements or findings that I've been discussing.
So when you say comparative, you mean A is better than, bid proposal A is better than proposal B
Yes.
on this? So it's not just ranking each proposal by how each did within its criteria, it's comparing them to one another?
Yes,
It's your proposal.
It's
Okay.
comparative. And you have each one of the evaluation areas as well. So then this is at the end of that particular part of the process, the category teams would then produce that comparative ratings and those factual statements in reports, which actually would be conveyed to the commission.
Right.
At that point, all the information is with the commissioners, and the commission would have the responsibility to hold a public meeting, to receive probably presentations regarding each one of those reports from the teams, then as well take the information under consideration, and then come back most likely at a decision-making meeting and award the license. So the information, there's no screening process involved. It goes from the category teams directly to the commission. In addition to that, and these questions already come up, but I would like to, there are some policy questions that I recognize there are many questions around this that you may also have. But if you look, one of the policy questions goes back to the beginning of the process when we talked about licensing, screening the applications and looking for completeness. And one of the questions to keep in mind is what action would the commission take concerning applicants who fail to provide requested information or applications that are not materially complete. So the commission has a very aggressive process. One thing that I didn't talk about days at all, but I should at least touch on that, is we're anticipating 7 days for the administrative process with the licensing group. We're talking about approximately within 55 days from the application receipt that the evaluation process is completed and the reports are generated, which leaves about 2 weeks for the commissioners to come up with a final decision, and that total is about 70 days from receipt of the application. There's I think some more other policy questions I'll just touch on briefly. One of them we are recommending, but I wanted to come back and talk about this. It's exactly that. Should the teams include a commissioner as a chair, staff, those with specific expertise, and appropriate consultants with needed expertise. So we have proposing that back to the commission. That's design of this proposal. We think it will be effective. Also, should the commission go forward with a project coordinator would be responsible to help with selection of advisors, participate with the teams, and facilitate the process. In the next sentence, it should be, there's a typo there, but it's the project coordinator will report to the executive director and may have a role in monitoring the applicant's progress after the award. And the last policy question.
Are you reading from some, oh, yes, go ahead.
Yes, I am, yes.
Yep.
A short attachment. What kind of product does the commission prefer to support its task of selecting an application for award of a license? The proposed process produces findings and ratings from the 5 evaluation teams that are submitted directly to the commission. And we have had discussions about other possible methods, which would be to have another group consolidate those, produce a consolidated version of findings plus a recommendation, or a rating 1, 2, 3, 4. We've talked about that method as well. Top 2 has also been under discussion, so those are just some of the miscellaneous examples. In the end, considering all those, we thought this seems to be the best way, and a lot of that had to do with the process of listening to the commissioners' discussion about involvement in the process and decision-making in the process. It seemed to assure that takes place with the commission. That's my summary.
Great. Commissioner McHugh and Stebbins first. Do you want to comment further? Or?
I think Director Day summarized this well. There is a second document that supplements this, and that is the chart that was initially prepared. It's also labeled 4C. A chart that was modified from one we've seen before. But it just breaks down what Commissioner Day so succinctly described day by day. It does show, however, and this chart that Director Day was talking about shows how event-packed these 55 days are, and that the 70-day period really packs a lot of energy and a lot of activity into the period from the time the RFA is received until the license is awarded. And that's an important thing to keep in mind, because as we cinch this down and get comfortable with whatever amounts of time we take here, it will have an impact on the way we process the Category 1 RFA 2, both in terms of whether we have the resources and whether we can get the resources, if there's an overlap between processing in both categories, and secondly, whether the time frames for processing the Category 1s we have, how to approach the time frames we have for processing the Category 1s. That's a subtopic. We really need to concentrate on this first, I think. The only other thing that I wanted to expand on very briefly is that the public input meetings are an example of what we just discussed a minute ago about topical public input. The idea here would be to go out in a relatively short period of a week. I've forgotten, Director Day, how much time, but a short period that we had allowed for that, to the various communities, and hold 1 or 2 or 3, as we decided, hearings in which we simply invited the members of the public to come in and tell us what they thought. We could do these, as Director Day said, with 1 or 2 commissioners going out. Could even do it simultaneously in different places. Listening, we'd have a transcript, and we'd have notes of the transcript to bring back to the commission and to the evaluation team so that we could have the public input. Then the public input would come in so that when the public hearing took place, the parties to which would be the applicant, the host community, and the surrounding communities, and the live impacted entertainment venues, those are the parties to that public hearing. They would have the benefit of the public comments to think about as they made, and we would as well, as they made their presentations. So we get the public's view, and at the same time have a hearing of manageable proportion. So that's the only piece that I really wanted to expand on.
In 7 days.
7 days.
7 days
for
is
those,
correct, yes.
yeah, for those hearings. So we'd be on the road a bit during those 7 days.
I'm sorry, please.
No, go ahead.
Well, I want to pick up on something here. First of all, I think this is a great summary and layout in general. I'm very much in favor of the process as laid out here. These category teams, with the involvement of commissioners, one commissioner, I guess, per team, sounds like. But I want to pick up on something that, first ask a question and then have more comments. You're thinking of one individual as a project coordinator? Is that your recommendation or thought?
That's my understanding of the
For each,
recommendation.
No.
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 Just one.
Just one.
One as a coordinator.
And I want to do that because I want to propose an alternative. I think there's a very large role for a coordinating piece. I think that's fundamental to this process. I think the days that we have are going to be jam-packed and very intensive. And if it's only one individual who's doing the coordinating, that may very well be the bottleneck or the critical resource. One day out could be significant from that person. I'm thinking that we should consider whether one person from each of the team has convenes periodically to a coordinating committee, let's say, or in a coordinating function, or at least have 5 people or one or more, I guess, come into a coordinating role.
Well, you're gonna have a staff person.
Right.
Already assigned to each of the 5.
Right.
If you had the project coordinator as the top coordinator and each of those 5 people as the coordinating team, would that accomplish what you're doing?
Well, I'm thinking through this. If it appears to me that this one coordinating person, this project coordinator, would have to attend each of these meetings, let's say, of the category teams. Is that correct? And the hearings?
No, I don't think
No?
so, no.
Oh,
I like this idea. I have worked a huge project with one coordinator. A really good project coordinator makes the whole thing come together. And it really has to be one person, I think. And part of it is keeping all the teams equally moving along, and making sure the right information is captured, and just keeping that whole project. It's a tricky role, but it's hard to do it with more than one person, I think. And they wouldn't attend every meeting, but they keep track of everything going on. And, usually, they may have someone helping them, by the way, but they're the coordinator. And I've had experience with this, and with the right person, it works really well, the one coordinator.
Your idea, sorry, do you want?
well, yeah, I'm just a little cautious that we have not identified this person yet necessarily, or have we?
It'd have to be a person, that there are groups that, for example, I did a whole promotional system, and one of the the company that's what that person did for the company, is be the project manager, and then they develop expertise, so it would have to be someone with experience at
Sure.
coordinating a project. And I'm just not sure where we go to get that person.
Well, I think somewhat what we envisioned was, and we've taken a stab at drafting responsibilities and roles and duties of this project coordinator position. Again, fully expecting it's a professional we hire from the outside. My original thinking was, it'd be great to find somebody who has some broad experience across, hopefully, a majority of the 5 categories that we're going to evaluate. So it's somebody who is not just good at making sure the trains are running on time, but it's somebody who may be able to come in and provide some food for thought on some additional questions that the review team might not be considering, but somebody who has a depth of experience with, development projects of this size.
I was just going to pick up on that and say that one of the things that we did find, and recognizing that there are a lot of differences between this and the way other entities, Department of Transportation, process things, we did get a number of people identified to us who do precisely this kind of thing, that they are hired to put together a team of financial, architectural, other kinds of specialties, and then run a project with actually much more decision-making responsibility in this kind of place. But they have that sort of diverse expertise to put it together and run it. So the people are out there and they're local, as well as national, international, global.
And I think it's significant that the commissioner chairs each one of these groups too, which would be a lot different if that wasn't the case, I think.
Right.
And
What is, under today's schedule, day one here, RFA 2 application submitted is what day?
Well,
What date?
for category 2?
Yeah.
It really depends. We've identified the possibility, we don't know how realistic that actually may be, that there may be early applicants. But this is really the deadline that we've set up for category 2.
October
So
5th.
August 5th.
October.
Sorry,
5th.
October 5th. And the duration for evaluation, assuming all applicants wait until the deadline to submit their applications, is currently 58 calendar days, I suspect. Yes, these are in calendar days.
So for purposes of that chart, Mr. Chairman, day one is that
October 5th, right, okay. So day 70 would then be
12 days beyond that.
12 days beyond, so mid-December?
Mid-December, yeah.
Correct.
12, 15.
12, 15.
Okay. Well, that,
Just for the record, I think that probably is a typo on that schedule. October 5th is a Saturday. I believe
Oh.
that we've been utilizing October 4th for quite some time.
okay,
Thank you.
okay. Well, I think this is a great job, and I like the process. The public input meetings, are they proposed to be by evaluation category or for the project overall?
It's my understanding they were for the project overall.
So it would be public comment, and then that would be, would be an extra meeting that's not required by the statute, but the hearings in host community is required by the statute. And you mentioned the live entertainment venues, surrounding communities, host communities, and bidders. Is that mandated in the statute, that they are the objective
They're the parties
participants?
to the hearing.
And
That's right.
is it exclusive?
No, we could add others, but those are the ones who are parties. They have,
Yeah, okay.
they have an opportunity and a right to be present.
Right, okay.
We could add others, but the idea here is to get the general public
Right.
information out early, so that by the time we get to that hearing, people know what
the issues are, yeah.
what the issues are.
Right.
The parties know what the issues are and can raise them. We can have a productive hearing.
Others?
Mr. Chairman, just as well on the, we've only touched briefly on the experts, the advisory, and the potential coordinator. We fully understand that as those experts would be identified and then potentially have a coordinator chosen, that those kind of things would come back to the commission. But to line up the resources and have that table set, that's part of the idea, is to get that ready
Right.
for the commission.
Right. Are we streaming? We are, okay, great. Okay, I have some other, anybody else have other questions, or?
Well, yeah, are we taking some of the policy questions
Well, yeah.
one at a time? Because I have a comment or
Yeah.
two about.
Go ahead, why don't you go ahead and take it from the top?
Yeah, the first one here regarding some action by the commission to applicants who failed to provide requested information. perhaps may go without saying that it would be easy to distinguish what's materially, missing. And everybody will know that when we get there. And if asked questions and they are non-responsive, that might be an easier decision. On the flip side, they may be also rather straightforward to figure out what's a minor cure. Maybe a page is missing and didn't transfer or cannot be read well, etc. So of course we're talking about sort of everything in the middle. My thought was that at some point, in some of these has some fluidity, request of information, additional information back, etc. That the category groups make a determination, much like you are, or a recommendation really, much like you're suggesting good, better, best, that there be a fourth one that says non-responsive in whatever piece of detail or subtopic they may want to talk about or to consider, and that is part of such process and so.
That's interesting. Would if a group said it was non-responsive, i.e. they just didn't respond to a thing, that applicant would stay in contention with a non-responsive rating for some category.
Or a subtopic, let's say.
And then the commission would take the non-responsiveness into account in making the overall judgment.
Right, by virtue of perhaps aggregating however many non-responsiveness, or taking that non-responsiveness in the context of everything else and making a decision that it was not material, or maybe it was, and therefore that's deemed.
That would obviate the necessity for making a materiality, non-materiality determination early on and kicking somebody out for a non-material, for a application that was not material, that was missing a material piece.
Right, well, that, we have to do that anyway. All I'm saying is,
Oh, I'm sorry, I thought this was a substitute for that, that's why.
no, I guess I'm thinking of those scenarios where it's not as clear cut. I'm thinking of, beyond the 7 days, let's say, that the director of licensing and his or her team have to review completeness. Of course, if something's incomplete, then that may be the end of it. But assume that it's not the case. That there is information that was requested after that, or perhaps asked to be further detailed, and that was not further detailed, or whatever the case may be. After that 7-day threshold, the group could make a recommendation on any one of these subcategories to say they were not responsive in this one subcategory. For example, such a group could say, we asked them to provide more detail, and the detail that they provided, either in the original packet or afterwards, we found to be insufficient. And therefore, that could be deemed non-responsive.
But what would happen if, at the stage where the staff looks at the application and determines that it is incomplete in a material way, i.e., let's just take a wild hypothetical, they don't have any financial information. At that point, is there an opportunity to cure, or is there the exit door?
We'd have to consider that and decide then, I suppose, unless we wanted to highlight what topics or items have to be cannot be missing, let's say. I'm thinking more again of the grayer areas.
No, I understand.
Assume that somebody submits.
I think we all agree. I think Commissioner McHugh likes the grayer, the smaller
Okay.
ideas. I do too. Let's go with that. I
All
like
right.
that. But I'm also with Judge McHugh on the issue of at the outset, if you've got a really material lapse in the application,
Yeah.
under what conditions do we permit it to be cured, and under what conditions do we say you're out? And I don't think we can wait until the time, I think, because it won't be, I mean, we've gone through this even with applicants in phase one, people are trying to change the nature of the applicant, and we're not sure how much you can change and so forth. So I think we need to have some standard, and I'm not quite sure what that is, but some standard, so that we can be pretty clear that who gets a chance to cure and who doesn't.
And just, I agree with that, and the experience in the first phase informs my thoughts about the second phase, as does the extremely tight timelines that we have here. We just can't give a cure opportunity, I think, for material deficiencies that is gonna drag on deeply into the process, because we're never gonna get the process finished on time. So we gotta figure out something to do early on.
Yep, I guess one way, and I would agree, one way as we finish the form of application, we could highlight specific areas that any missing information from any one of these or all of these topics would be considered material deficiency.
I think I'd be surprised if we received applications that are substantially incomplete. I think there will be many minor problems, and then an experienced director of licensing will understand and have experience in how to cure those issues. I think many of our issues around the first phase, where it was new, it's a very different process than has been used in other jurisdictions as far as host communities and votes, and when do they need to know all of that? I mean, I think there were some things that may have been just different experience. I think this second phase will not be that. And I, at least the way I anticipate this, would be surprised if we have an applicant who's come this far in the process to have a whole section that's missing. We have a decision that person would be out at that phase. I'd be surprised.
I would too, but I'm surprised that an RFA one bidder had a 20% owner that wouldn't participate, in the background check. So I think we have to be prepared. I agree with you. I think it's unlikely, but we have to be prepared just in case. What about using as a no-go standard the minimum requirements under the general law, your first category here? That if you, let me just throw out a straw man. If the director of licensing deems that there is some critical issue, and I'm gonna suggest that it's the minimum requirements, missing, they can cure through the 7 days. You have a right to cure through the 7 days. If you are still missing after that 7-day period any one of those criteria in the judgment of the director of licensing, you're out. That is a decision which can be appealed to us, but that's it. Everything else we deal with the way Commissioner Zuniga suggested, that in the review, if we think some of these other categories that have either not responded at all or responded woefully,
Or
we take that
vague.
into consideration.
Yep.
But it's not curable, but it is taken into consideration in the fashion that you discussed.
Yep.
We did consider affording the project coordinator the opportunity to obviously go back and clarify information that was presented, but, clearly under section 15, we have the basic requirements. Your surrounding community agreements, your agreements with, copy of the vote from the host community, all of those things. I mean, I would think within the 7-day period that, I agree with you, Mr. Chairman, those should all be curable. I mean, they're in the statute. But moving on to the next phase, where we may go through the evaluation criteria and see some information is missing, I want to put some onus back on the applicant themselves to say, you want to stand up, you want to bolster your application. We shouldn't be chasing you down for that information when really you're trying to demonstrate the strength of your application.
I agree with that completely. So are we okay with that? So does that make sense, do you think, to use the labeled in beige, whatever that color is, flesh tone, minimum requirements, as non-negotiable materiality, standard of materiality, which is curable 7 days from the closing date of receipt of applications.
Yeah, I was just looking through them, and I think that would work. I think that would work, and then if it is, I was just running through in my own mind, if it's sort of a pro forma compliance, we'd ask for an affirmative action plan, for example. Suppose the affirmative action plan is, we're gonna try our very best to be diverse. Then that would go into the evaluation as
Non-responsive.
Non-responsive, yeah.
Right. Or, yeah, or because,
Right.
because it's not
No, I
clear,
think-
it's
I
not
think that would-
sufficient.
right.
Yep.
Right.
Certainly not the best
But
rate.
it's there. Right.
Commissioners, could I just ask
Sure.
a procedural question? Just, I think in the end, and I don't think I mentioned this in very much detail, but as the licensing group is reviewing those applications and we've identified the no-go part or the material deficient, but they may very well identify whether it's affirmative action plan is meeting. In my mind, in the normal processing methodology, they would actually notify the applicant and say, you have X number of days to turn in the information. I think the thought is that notice would go with the information to the category team, but the process would move forward, so there wouldn't be any delay in it. And if that information, when it came in, the category, it kind of depends on whether they added it when they were requested to do, whether they never added it. The category team would have that ability to take that into consideration too in their rating. But it would at least allow those kind of corrections or additions to the applicants the ability to fill in those parts that are specifically notified. It's more of an administrative process.
Yeah, I mean, I prefer putting our foot down. I mean, if you can't get these pieces in, then you don't have any business being in this game, I don't think. I mean, and why should we, stretch ourselves at all, to accommodate what would be really, negligent, practically behavior. So I would rather have be pretty rigorous on, these are bare minimum, they've been in the law for 1.5 years already. So I would rather do it at the end of 7 days, you're out.
But those miscellaneous issues, I mean,
The miscellaneous issues would go ahead in the process.
would
that
just
we-
go ahead, just,
Right.
we'd notify them, we'd say that this little piece is missing, or you forgot somebody's name, or something like that, and then move the category information forward along with the letter that had been sent, most likely about that. Or do you
I
want to
see what
just?
you're saying. No, that's an interesting.
You want to just note the deficiency and,
I think that they have the opportunity to correct within 7 days. I think that there's no downside in doing that, allowing them it's not a lot of time. So if it's really an incomplete application, that would be difficult, but for small things that may be, for whatever reason, just weren't supplied, I don't see any problem with allowing 7 days and the licensing team to, immediately notify and let them correct, and then, but 7 days later, that goes to the category team.
yeah. My thought is when the licensing team was done, they would move that information forward to the category team.
But you're saying that the bidder would, for things other than the threshold issues.
Correct.
That the bidder would have time after the 7
Yes.
days to fill.
Would have a specific
to finish.
date, and, because the category teams their evaluation teams are going to be working for a while.
Right.
And so it would seem like there would be a reasonable ability to incorporate that kind of correction in that process, as long as it wasn't in those major category areas. And they would be on the hook to make sure they made the date that was given them by the licensing group.
So the date could be, say, 2 weeks or 3 weeks, is what you're saying, and then all that information moves forward? Is that what you're saying?
I'm saying that the overall, the application comes in, the licensing team is screening it, they identify anything that's incomplete, notify the applicant that you have 7 days to provide it.
Right.
Move the information per category on to the evaluation team, so nothing's holding up that
Yes.
process. And along with that, the information that goes over would be the letter saying, you forgot to add Susie to the application, or this seems to be missing, and what's the answer to it? So the team would be able to continue with its work, and would see that there's a missing document in that process.
How about if we had how if we had two deadlines for the material stuff, what we're gonna call the threshold issues? That is the same, the first 7-day period. If you're not in, that 7 days, you're out, period, it's over. But for non-material, other kinds of deficiencies, there is a second week, meaning 14 days from the application date. Because that would give them a week, basically, from the end of the 7 days. If they got notified on the 7th day, they'd have a week to get Susie's signature in. And at the end of the second week, it will be dealt with in the way that Commissioner Zuniga, there'll be no more corrections, to fill in omissions. And it will be accommodated by non-responsive in the waiting. How does that sound?
And does that mean you want us, the licensing group, to hold the information, or
No,
still
you
go
go
ahead
ahead.
with the
No,
process?
you go ahead.
You go ahead, as soon as you're ready. I mean, that wouldn't have to be on day 7, it could be day 3 if you had vetted them.
Okay.
But the bidders would know they had a total of 14 days to get the non-material omissions
Okay.
cured. That sounds,
That works.
Sounds good.
okay, great.
Just the final thing. What we are thinking, both in the material and non-material omissions, of complete omissions. Anything that's qualitative, i.e. it's there but it's junk, is going to be dealt with in the evaluation process as lousy or non-responsive,
Mhm.
right? So
That's
we're not
correct.
going
It's
to make a
evaluation.
qualitative determination.
That's right.
of adequacy of the information.
That's right.
Using your affirmative
Right,
action
right,
as an
right,
example.
right.
Yep.
I think that's good.
Mhm.
I think that's great.
Yep.
Okay. You want to just keep going through your policy questions? Or
Sure.
any other questions on this?
Well, I guess the other one, we did talk about, and I guess I assumed the project coordinator would be attending each of these working groups, but that doesn't seem to be the case, so I'll move on from that.
The 1 hour to make a presentation, this will be the sine qua non presentation of all these massive projects. And I wonder whether an hour is enough. I don't know. I mean,
We didn't discuss where that number came from, but the number did come from the Philadelphia experience, where they had 6 competitors for a single license, and they were given an hour to come in and make their presentation. There's no magic to an hour, and I think that's a good question. The better show people, men and women, do better with that kind of compressed time. And maybe it's better to spread it out over 2 days and give 2 hours each. 4 hours.
Well, it's going to be there'll be a maximum of 4 per
Right.
license, so
Right.
we could do it one day if we needed to, if for a couple hours. I don't know, I'm thinking out loud here. It sort of
Right.
seems to me like there's so much going into these things, and it is tactile. It isn't just something on paper, you do
Right.
want to
Right.
see the
Right.
proposal
Right.
and see the videos
Right.
and so forth.
Right.
And if I were doing it, I would want a chance to really show my stuff,
Right. Right.
So, and I think we would benefit from that. I mean, we
Right.
would benefit from the bidders having a real opportunity to really show their stuff.
Right,
Meet the people, see some of the people in the flesh.
right.
How do we feel about 90 minutes? I think there is some benefit to doing it in one day. There's no advantage one way or the other.
Yes.
So I think if we did 2 in the morning and 2 in the afternoon, you say there were 4, that might, and there's a skill set involved with getting to the highlights,
Yeah,
and that's important as well.
yeah. Well, I like 90 better than 60,
Mhm.
That doesn't necessarily, I mean, that time constraint doesn't limit the amount of time that we have to make questions to an applicant. It's an hour and a half for them to make a presentation. We can spend another 30 minutes asking more detailed questions about their presentation if we so choose.
Was that the
I
expectation,
don't-
that we would make questions, or?
And at least from my perspective, I would think the commission probably wouldn't want to ask questions in an overview presentation, because then it could
Yeah.
change the amount of information conveyed or from each applicant. Is where you have, if you have a standard process, I think it was a visit really as an informational process that allows the applicants to come in, assume the evaluation teams would be present, listen to the overall presentation, and then go start the evaluation work. Later on is the host community agreement discussion as well with the applicant presentation. That is a question and answer process, but I think initially it would just might have more questions from one applicant. They'd have more time than the other one. And
Which applicant presentation are you talking about?
It's in here at the end. It's at the end of,
Host, the statutory hearing.
Statutory host community.
Oh, okay,
Yeah.
okay. Okay.
That was my understanding too, no questions,
No
just a
questions here.
presentation.
right. Well, what, just for whatever it's worth, my experience with, when we were conducted interviews as we procured bankers, is that everybody wanted to go last. So we'd have to think about, whether we do some kind of lottery for this process, by the way. But if we kept it to a day, we minimize that posturing perhaps, because, some will consider that to be the best position, I guess. But if it's all done in a day,
Well, I think an hour and a half makes sense, so, and that gives us a little bit of flexibility, so we'll all be dying if it's much longer than that, so. All right. So 90 minutes, no questions, one day, order we'll figure out by law. Great. Well, assigning the commissioners, I guess we got until October 5th to figure out which commissioner takes which category, so there's no rush on that one. Here's something that we talked about last time, and I'm still haven't quite got in my mind. So the evaluation teams look at, let's say the slots, let's say we do indeed have 4 proposals. Each evaluation team for each of the 5 categories does an item by item from the evaluation criteria, I guess. ABC, good, better, best, not responsive, and then does an overall, I guess, as among the 4 of them, what rank the team thinks they are within the one category. So then you'll have, in effect, let's see, you'll then have a ranking. When you compile those, you'll have a ranking. Somebody got 3 firsts and 2 seconds, and they rank higher than the person who got 2 firsts and 1 second, or 1 first and 1 second. So that will suggest that there's the answer. The guy who comes out on top wins. Or it will suggest that there has been a rational process which has put bidder A on top. How do we justify, the bidder might say, if they end up not winning? So how do we manage that? So how do we manage the expectations? How do we not limit our own flexibility? How do we play fair? I mean, how do we deal with that?
Why do we have to take that that compilation step, rather than take the assembled results of the 5 teams that have them with the categories, and then the overall ranking for that category, and then without saying automatically, if you got 3 firsts, and the other person only got 2 firsts, you're at the top of the combined list. Take a look at what it is they got the firsts in. Because the qualitative piece, it seems to me, is ultimately got to drive the outcome here. And it may be that by the time we finish looking at these, the drivers of our ultimate decision are going to be different from the drivers we would have anticipated before we got into this process. So to create a structure that automatically gave some kind of a ranking system based on a mechanical approach to who got how many firsts wouldn't necessarily do the job and would lead exactly to the problem that you're talking about, I think. And if we talked our way through it in a public meeting, came to a consensus as to, given everything we've got, these are the most important criteria, and then went back and looked at who did best under those criteria, we'd be preserving our discretion and also gearing our decision to what we were dealing with.
And it could be that they were barely first, and in one category, very low, which would,
So does the evaluation team end up do a ranking
Of people within that category.
within their category?
Right.
Right,
They don't
but
know
it's
what
not,
the
a-
other
but
groups-
it's not a function of who got the most firsts.
Right.
It will be a subjective thing,
Right.
taking into consideration
Right.
how you did on these
Right.
multiple good, better,
Right.
bests.
And that would be by each ranking team, and then overall, as we got, as a commission, the results of the ranking team's efforts, we'd go through essentially the same process.
Right, so you would have a situation, let's say we have four, you would, if somebody comes in first in 3 of the 5 categories, and second in the other 2, first of all, we're not gonna set that up, but it will be on paper.
It'll
So
be visible,
People
right,
will see that. So we just make it clear that this will continue to be a subjective process where we will consider how they did in each of the 5 categories, but in the process of threshing it out,
Right.
we are free to weight however we end up weighting their 1s and 2s and 3s and so forth. Is that it?
Yeah, that's what, and can I just, to give an example, we may, for why I think this is a good idea, somebody may be head and shoulders above everybody else in the financial yield category. And the other, there may be another applicant who's got 3 firsts in the architectural design, the, I forgot what the other
Mitigation.
categories are.
Mitigation.
Mitigation and others, but one applicant is gonna give to the Commonwealth realistically twice as much of a yield and create twice as many jobs as the others. That's a reason for not saying
Right.
3 first wins.
Right. Okay. Does that
Yeah,
make
I'm,
sense?
I mean, in
Yeah.
full agreement with that. I will only edit from what you said, Mr. Chairman, subjective. It's qualitative. What we're, the analysis will be objective,
Okay, thank you.
but it's in many of these, there's a qualitative nature. There's the relativeness would be up to the discretion first of the groups. The good, better, best is a tool that could be used in multiple ways,
Right.
but we need to have the flexibility to distinguish that one is perhaps
Right.
head above others within the categories or among the large categories. And that invariably, we may not know it until we see it.
Right.
Meaning,
I think that's very good. I like that. I think it's very important that it be written out and
Right.
on various places. I mean,
Right.
everybody's here pretty much, they're hearing us, but I think, because there will be a tendency for people to want to rank them, to count them up. And we want to neutralize that as quickly as possible, and it should be I'd say it should be on the application process. It should be maybe in our regs or at least somewhere, so it's really clear to everybody how we will do this, and that the qualitative nature, how that will control, and how we will not be, controlled by any kind of a mechanical ranking.
I think that there's a foundation for it in the regs now, but, in the drafts now, but we'll have to
Beef that
make
up.
sure this whole conversation is reflected in the regs as we go forward.
are we gonna take these at a later
Yeah,
time?
it's on the, it's, which one where is that? I forget. It's,
7?
Yeah, okay.
7B.
Because we
Yeah,
could go back to
7B,
these,
yeah.
there's a best and final
Yeah.
discussion that, where some of these bears into mind.
Right.
So we
We'll get to
just
that.
come back to
Yeah.
this as well.
okay, good. I think that was helpful, at least it was for me. So, The policy question, should teams include a commissioner's chair, staff, expertise? I think the answer to that is clearly yes. I think we've discussed your project manager, coordinator idea. We like the idea. They ought to be on board. There's no rush, because this is gonna be October, but with a couple of months, I would say, in advance of October, so they can really begin to understand what's going on here and help us set up the processes and the paper flow and so forth.
Mr. Chairman, I would actually argue that, in selecting and forming the rest of the group, selecting advisors, it may be worthwhile identifying, who may be as part of the commission and the staff in these groups prior to October.
Sooner
Oh,
rather.
yeah, absolutely, yeah. Right, I totally agree. I was saying 60 days, at least 60 days
Okay.
before its closing date, we should have our project coordinator as well as the staff
Yes.
and everybody else,
Okay.
so they can start working together and get warmed up. Commission will hold a public hearing to consider the evaluation team reports. Commission will then hold a final hearing to award the license. I guess that's non-controversial, right? Oh, I see, and then no, well, the only question I still have is, what constitutes an award for triggering the payment? How do we manifest that decision that then triggers the license fee?
The draft regs, and we can talk about that when we come to
Okay.
that, say that the
Majority.
vote is the award of the license.
Okay.
And the 30-day period starts and then we have a 30-day period for paying the 85 million or 25 million. And it starts on the day of the vote.
Okay.
So we can talk about that, but that's what's in the regs.
Okay. My last thing on this is, the regs reflect some of the evaluation criteria, not all of them. The evaluation criteria probably reflects all of our evaluation criteria, but may not. I mean, we might think of some other things as we're talking about this. And I wonder, do we need to do anything in the regs or in the evaluation or both to make sure that we're left the freedom to, think about something we haven't yet thought about?
Well, let me deal with those in that order. The regs now, and we'll see that as we get to them, the regs now basically say that the evaluation criteria we're going to use are the major topics and the major subtopics, i.e., overview doesn't have any subtopics, but when you get to financial, are going to be financial, and then subtopics include principal and capital structure. And then the application will take these things in the right-hand column, incorporate them as evidence that we need to help us figure out how you've done on that subtopic. The current regs say that we are going to use these evaluation criteria among others, I believe. So we've left ourselves some flexibility.
Among these criteria, among
Among
others, not
others.
the ones that are
Not-
just in the regs.
That's
Right.
right, that's
Okay.
beyond what's listed in the regs. And the application will have some kind of a similar caveat. That said, we've got to be careful about a Pennsylvania problem. And it's not fair to start to use, particularly as a dispositive criterion, something we never told anybody about. So if something emerges at some point, we would, it seems to me, at the very least, have to notify applicants that some issue we hadn't thought about had come up and give them an opportunity to give us information, or not consider that criterion in the evaluation process. It seems to me that if something we overlooked comes up, it's going to come up very quickly after we get the RFA 2 applications. So as a practical matter, we'll probably be able to give that kind of notice without holding things up. But apart from that,
We did a lot of work on this. I think it's highly unlikely, too.
Right.
But I think we should be covered, so as long as the application and the regs do give us flexibility,
Right.
if something comes up, we can deal with it at the time, as long as we have the flexibility to do it. And that might mean ask for other people, whatever, it depends on what it is, but okay, I just want to make sure we have that room. Anything else on 4C little I?
Chairman Crosby?
Yes.
Just a question from my perspective, and the schedule that we've taken a look at that has the 58 days there, I'm assuming by the discussion, the commission's pretty much acknowledging that we're going to move in 70 days for that evaluation is going to be moving right along, so as we come up with a master schedule discussion at the end of the month, that would change those dates.
So you're asking, are we agreeing with the 70-day
Yes.
plan that you proposed here? And I think we are, right?
Yes.
Yes.
Yeah.
Okay, thank you.
Great. Yeah, it's a great job, the commissioners and staff, you know, it's a lot of stuff. So we're now at 4C little I, 2 little I, evaluation team.
Well,
Did we need a vote?
We need to cinch down, it says vote here, we need to
Oh, sorry.
agree that this matrix, 4C little I, the current evaluation criteria matrix, is the one that we're satisfied with. And that is one that we've basically seen before, except in the source column at the far right, there are some indications of where we got and adopted, or proposed to adopt, Commissioner Stebbins and I, some changes based on outside input. The changes themselves are in red. If there is a indication in that source column of a suggestion, but there is no red, it means that the source suggested we take an existing criterion and simply put it in a different place. But the type that's in red are changes, and the initials to the right are the source. MGC, of course, is us. MOTT is the Mass Office of Tourism. DI is
Donahue Institute.
Donahue Institute. And CCG is the problem gaming folks.
Right.
And DOER is Department of Environment,
Energy Resources.
Energy Resources.
Yeah, I didn't see those, thank you for getting those out.
Again, those are not new criteria so much as they are additional pieces of evidence supporting a criterion and an approach to a criterion.
And the other important standard for this, as we adopt this, is, and I think some of us at least, you and I at least talked about this, is to make absolutely sure that we've anticipated Region C too. Because we are maintaining to the applicants, prospective applicants for Region C, that they will be held to the same standards
Right.
as the applicants for A and B are.
Right.
And that means we'll use this set of evaluation criteria and no others. And I think that works. You know, the big issue obviously will be the issue of the tribal casino, but there is plenty of place in this evaluation criteria for bidders to demonstrate their financial sustainability, their relationship to the competitive environment and so forth. So we won't be asking anything of Region C that we're not asking of A and B.
There is some, primarily in 2 of the criteria area that we came across, where we did some consolidation, but as we look at review teams, where somebody might be assigned to one review team, but may have some follow-over expertise needed on another review team, traffic, for instance. Building and site design focuses on traffic patterns around the property, but yet, under mitigation, we worry about traffic. So you may have an expert who is
Can be part of 2 committees.
straddling 2
Yeah.
criteria.
Mhm.
And security was the same way. We knew there were security components of building and site design, but also mitigation strategies with respect to security. But we kind of combined them all into the building and site design. But again, you may have an expert from kind of straddling 2 review teams to analyze everything security related.
I think this is great. There's great additions here from our friends from these other organizations. And I think we should adopt it. There's a lot of work. I would only note that there may be a tweak here and there or there in the future. I'm specifically thinking of the discount rate to use for modeling. That could be something else than what's here, 4%. It could be something different. And I'm sure we'll have the ability to do that as we move along, if we had to change it.
Yeah. I think in terms of the evidence is flexible, be reflected ultimately in the application form. It's the criteria that are
Yep.
important.
Okay. Next.
In the evaluation teams, we already covered in the makeup of those in the prior
okay.
discussion. Yeah, we just consolidated those, so I think.
I thought that was referring to the RFPs that have to go out to get consultants. Where are we, where are we in that process?
That process is currently in progress, I guess, and the idea is that we go about a process, it's the big we with Bruce and go about a process of identifying the appropriate expertise for each of the advisory groups. Once we've assembled that, what we think, and for the project coordinator, then the approval process would be back with the commission. So they're in the process right now. Like Bruce, Commissioner Stebbins already identified that he's got a draft job description for the, or work description for the coordinator. He's already, Commissioner Zuniga has already got financial, identifying financial interest in.
We have a good, strong outline for the building and site design RFP. Financial advisor RFP is pretty much ready to go.
Yep.
And then the other one we're still looking at is just the foundation for the economic development criteria review.
Okay. So those don't need to be approved by the commission. Those, they're technically, I think we had said they had to be out by the 17th to technically go by our schedule.
Right.
So if, it sounds like within a few days, at the most, you're ready for those to go out.
One's ready to go, and I would say within the next week and a half, I'll have the other ones ready to line up.
Right, and we will post them and we'll get responses, and that would be ultimately approved. But last week, we actually delegated that posting
Okay.
to Commission, to Director
Okay.
Day, so
Great.
we're.
That was
in good
my
shape.
understanding too,
Yep.
is
Okay.
in the previous meeting, to move forward and
Right.
identify those expertise,
Right.
and then when it comes to the actual commitment, come back here.
You have to bear with your aging commissioners. Sometimes they forget things.
Only 1 out of 4, 1 out of 5. Speak for yourself.
Speak for
2 out of
yourself.
5.
Okay, great. Thank you very much.
Thank you, Chair.
So did we need a vote for this evaluation?
Actually, we
right,
should.
yeah.
Yeah, we probably should. Yeah, so I guess maybe Commissioner McHugh, do you
All
want
right,
to?
I move that we, the commission adopt as its evaluation matrix, and thus the basis for constructing the application and evaluating responses to the RFA 2 applications. The version of the matrix currently embodied in 4C1 of today's meeting packet.
Second.
Any further discussion? All in favor, say aye.
Aye.
Opposed? Ayes have it unanimously. For this and other stuff in today's package, you and your staff have done a great job. You know, we'll work bugs out of the system about this new process, but there's been a ton of really good work that's been done by all of you, and I appreciate it.
Thank you, Chairman.
Next up is supposed to be the ombudsman report, but I know we have somebody who's come from out of town. Rachel, would it enhance your life if you went now rather than waiting for a little while? We're more than happy to have you come now if you want. If you don't care, you're gonna be here.
I brought my computer, I was planning to be here.
So it's okay, you're cool one way or the other?
Yeah.
All right, so we are gonna do you, before we go through the regs, we'll spare you that. But otherwise, we'll go ahead. Let's get ombudsman. Do you want to take a real quick break?
Sure.
Yeah, it's been a couple hours. Let's take a real quick break and then we'll convene with John.
I thought the regs were the highlight of the
We are now to item number 5 on our agenda, the Ombudsman's report. Ombudsman Ziemba.
Thank you, Mr. Chairman. I'm here today to discuss two matters. One is the Phase 2 Category 1 application deadline comments, and 2 is a draft Regency application process. Recently, the Commission put out a question for comment, which I'll read. Should the Commission move its Category 1 application deadline from its current projected December 31st, 2013 date to a date at the beginning of December to be able to incorporate additional time needed to resolve issues such as disagreements between applicants and surrounding communities? Could the Commission move up this Category 1 application deadline even earlier, perhaps to the beginning of November? We received numerous comments that have it's sort of a very wide range of comments, both against moving things forward and for moving things forward even earlier. We received 4 comments asking us to extend our deadline even after our current December 31st deadline. We received a couple of comments to stay at our current December 31st deadline. We received 3 comments supporting our moving up to December 1st or early part of December. There was 1 comment supporting the move to November 1st, and 3 comments asking us to move them earlier. I'll go over the general flavor of the comments. MAPC, which recommended extending the deadline, recommended that we should extend the deadline by 1 month to take into account time necessary to conclude surrounding community agreements. And similar concerns were raised by Berkeley and Medway, their boards of selectmen, saying that our deadline should be extended because of the compressed time frame to negotiate surrounding community agreements. Milford Board of Selectmen Brian Murray asked for additional time to prepare the application, noting that there's extensive requirements and that additional time would be helpful in preparing an application for the Commission. And he also stressed the fact that we had an originally publicized application date of December 31st, that even though it has been a draft date for quite some time, they noted that people are beginning to count on that or have been counting on that deadline for quite some time. Similarly, from the stay at December 31st comments, Robert Allen, on behalf of Crossroads, made a similar argument to the Milford Board of Selectmen, whereby they asked for that it takes a little while to complete applications, and noted the December 31st deadline that has been out there for quite some time. Hard Rock submitted some very extensive comments on why the December 31st deadline would be useful. Specifically, they noted that it would hinder our application process because it might reduce the quality of the applications that we received. They noted that even in our draft regulations, there are very substantial categories of information that need to be submitted to the Commission, and that many of these require substantial negotiation with outside independent parties, notably surrounding communities, host communities, live entertainment venues, and the like. One thing they did mention is that there, in addition to state processes, that the time that it would take to get the local zoning approvals also might warrant at least the December 31st deadline. And they also noted that they are likely to file something that is akin to an expanded environmental notification form that includes a tremendous amount of detail in their proposal, and they are expecting additional comment period over and above the 30-day E&F period that includes the comment period. From the support of December 1st grouping, the Greater Boston Labor Council appreciated the Commission's efforts to move forward and recommended that we continue to look at efficiencies in our process. Similarly, the Labor's Local 22 made the same mention, and the City of Boston urged us to support the December 1st deadline, noting that they've been urging the Commission to move as quickly as it can in the past. Support of November 1st, Springfield. Springfield recommended that we move forward, noting that it just recently executed its host community agreement and will likely have its referendum completed in short order, and that the shorter deadline would incent surrounding communities to move expeditiously in reaching surrounding community agreements. Notably, the comments that asked us to move forward, we had very extensive comments from Sterling Suffolk. We had some equally robust comments from the town of Hopkinton. One represents obviously an applicant and one represents a surrounding community. The town of Hopkinton's comments were that we should establish our deadline as early as possible to provide time basically after the application to resolve surrounding community disputes. And then the Sterling Suffolk comment period noted that there are very, very substantial days that will be necessary for both the potential disputes with surrounding communities and also just the general reviews after you take into account hearings, take into account staff reviews, and that a December 31st deadline could push the actual award of the license into sometime in early spring of 2014. And they noted that that is pretty close to the end of the fiscal year. And then Joe Ayano also recommended that we move as quickly as possible.
Yes, and?
Oh, I think what we decided that we were going to think about today was that if you're looking for a recommendation of moving earlier or later, I think what we thought we would do is, noting that Director Day just gave a pretty extensive analysis of the time that it would take to do all the staff work that goes into the post-application round, that should be fully incorporated into our decision on when we would move, where we would move the application. Because it's not only the time that it would take for the applicants and the surrounding communities to get their issues in order, but it's also how close would we be to either the end of the fiscal year, or how long would it take for our licensing decisions and how that impacts the earlier dates.
Comments, reactions?
I agree with the suggestion that we ought not make that decision today, that we ought to take the process that we've now agreed on and the days that process will take and lay it on the Category 2 process, the Category 1 processing, recognizing that the Category 1, we're going to have more in number and we're going to have more in complexity. And there are two ways to handle that. The first way is to see what it will take just using the staff we currently anticipate and the pieces that we currently anticipate for Category 2, and see what a realistic timeline is. Another is to put those pieces together in the shortest possible timeline and see what additional staff we need. But one way or the other, it seems to me we ought to make the judgment on whether to move it forward, and move the deadline up earlier, or leave it the same. I don't think there's much consideration for pushing it back, but maybe there is, based on that kind of a precise analysis, rather than put out another date that really will be problematic. And I suspect we could do that in a couple of weeks.
I'd be fine with that. I don't think we can wait much more than a couple of weeks, because people really are beginning to rely on it. I must say, I've had an epiphany on this. I've begun to feel pressure to make judgments about this issue because of meeting the budget pressure for the state.
Right.
And that is a mistake. And if I'm just speaking for myself, I mean, I don't want to be affected by that. We got to figure out how to do this, and there are good reasons not to extend, not to move it up. There are as many people who want us to slow down or speed up. It's about 50-50 at this point, but there have people have been relying on it. We're going to have our hands unbelievably full, no matter what that, the details look like. If we don't get the money in by this fiscal year, the legislature, if it needed to, could borrow from the rainy day fund and pay it back when the money comes in, so it's not catastrophic. And I don't like having, I was responding to the wrong pressure here, so I've come to the conclusion that I would not want to move it back. I would go with where it was. The only compelling reason to make it earlier is so we have more time to get the money in that fiscal year budget, which if we can possibly do it, we will, but I don't think that's a good enough reason to cause anybody any heartburn, and I think a move of the month would cause a fair amount of heartburn, including to us, since we're gonna be so small. But we don't have to, I mean, if everybody agreed with me, we could decide today, but if not, we can wait until we look at it at our next meeting.
I agree, trying to really finalize it in the next meeting. There are important considerations in terms of duration that still need to be reflected here. There is a second one, which is that some of these Category 1 and Category 2 are going to be in parallel to the resource. There's going to be perhaps Category 1 hearings about suitability, et cetera, and that takes resources as well, not just commission time, but notably staff. So that has to be laid out with more precision, and I think we have the tools to do that as of today.
So you're still open to the idea of moving it back? You'd like to explore whether we could make it December 1st rather than?
Yes, yeah, I think I would agree also with the notion that I don't know that we have the need to move it later necessarily. But the point is really that to try to finalize a deadline as soon as possible, and I think next meeting may be really the target.
All right, so let's set that objective to decide this once and for all next meeting. Okay. There's a lot of, still, no matter how hard we try, misunderstanding about what's going on in this comment. You know, particularly a lot of the area around the Milford proposal. Communities, lawyers, towns, they don't understand the process still. There's a lot of wrong assumptions in this. We've just got to keep trying to get people to understand how the process really works.
Right, and, Ms. Driscoll and I have been discussing additional ways to try to get out the message, and I think it's just even more important for me to just be out there as much as I possibly can out in the communities for these sessions. The regional planning agency sessions that we have anticipated, they're about to begin soon, and that'll be an additional way for everyone to get information about all of our procedures. And I think we noted just the other night at a forum that they're beginning to become rather complex and complicated. So it's quite understandable that people would have questions and may not get things exactly right the first time. But that's why it's on us to continue to go out and go out and go out. And we'll try to do that.
Two of these letters, one was from Greenberg Twerg, who are they representing? Hard Rock. And another one was, I think, from maybe Hopkinton, talked about they have a schedule, asking us not to change the time frame because they have a schedule already. And you had, I think, or we had asked for very specific feedback so we could actually see what the problems were.
Right.
It'd be useful if those two organizations would show us their schedules so we can understand, you know, why they think it's a problem.
Right.
Even though I'm not in favor of it anymore.
Right.
Okay.
Okay, thank you. So what we've done is we have created a draft Regency schedule after internal discussions of staff, taking a look at what our current schedule was. We took a look at the draft schedule that we put forward a little bit earlier this year. And what we have before you is a draft that can be considered. And what I do note is that this draft that we have before you is subject to some adjustment based on considerations that may come about as we go through the application process, or obviously now as we take a look at some of its parameters. But if you take a look at what we have previously put out as what we previously put out as a draft timetable, I'll just share some of the big headline dates. prior to this, we had an RFA Phase 1 deadline of roughly about August 2013. And again, the first timetable that we put out was, I think we prefaced our comments that this is a very, very rough outline, but I think that the rough outline comes out to be, pretty accurate when you take a look at all of our existing procedures. So the RFA Phase 1 deadline, originally we had an August 2013 Phase 1 deadline. The recommendation I'm putting before you gives us an October 3rd RFA Phase 1 deadline. Suitability determinations of May 2014. This recommendation is right about that same time frame. It puts forward an IEB report from March 23rd. MGC, the commission review of the IEB report, 4/28, and then a final suitability determination of July 8th, but that's after appeals, if indeed there are any appeals. The Phase 2 deadline for the RFP, initially there was an August 2014 timetable, and this recommends a early September deadline, 9/3/2014 deadline. And then a licensing decision, we had December 2014, and very similarly, the licensing decision is a December 2014 recommendation here, with a range of the beginning of the month, 12/1 to 12/31. Now, this recommendation, we have a sheet that puts forward a number of different reasons, the benefits of this proposed schedule. But what we generally did is we tried to think of the difficulties that we've been facing in this current round and how they could be remedied in an upcoming round. And we also tried to take into account staffing constraints during this funding round so that we wouldn't necessarily impact both the current A and B applications and unnecessarily complicate and delay a Region C application. What this puts forward is a reasonable period for background investigations based on a likely number, reduced number of applicants. Obviously, we have no idea how many applicants are out there, but given the smaller geographic area, I think that's probably a reasonable assumption. We have 171 days for that background check. This is designed to limit the impact on our current background reviews by starting the qualifier at the scoping meetings after, generally after we finish our determinations of suitability for the A and B rounds. So if we start the qualifier rounds in September 3rd, that is roughly at the very end of our suitability determinations, and hopefully we can conclude the suitability determinations earlier in August. What it's designed to do is to enable communities to vote on referenda after our suitability reviews are completed. We've all faced the issues of the awkwardness of communities having to move forward on referendums before there's a determination of suitability, and hopefully this would alleviate that discomfort. It's hopefully designed to avoid any summer elections. We're hoping for elections basically around June 2014. It gives communities time to plan by requiring a site designation fairly early in the process. Now, this is a new recommendation that we're putting forward, which is unlike our current round where there is no site designation basically until the time of the application, the RFA2 application. What we're asking is that applicants have to designate a site after a certain period of time. And what this would do is would enable greater planning by host communities, potential surrounding communities, so that there'd be a little bit less confusion out there. But what it does is that it gives applicants a little additional time to find the site beyond the RFA 1 application date. So what we recommend is that we would establish a site designation date of the end of the year, December 31st, but that the applicants would begin the qualifications phase, the first phase, on October 3rd, thereby giving them a couple of months to find a site or to nail down a site if they haven't done so already by October 3rd. So what this does is it gives at least 4 months after that latest date, that December 31st date, for host communities to execute a host community agreement. And it gives at least 8 months after that site designation date for surrounding community agreements. And 4 and 8, that leaves about 4 months between the time of the host community agreement and the surrounding community agreements. And hopefully that enables surrounding communities to get some of the technical assistance after the host community agreement, if it hasn't been provided earlier, to enable them to enter into surrounding community agreements. As I said, we can modify this a little bit more quickly depending on circumstances. If there are fewer number of bidders, if we think that some of the bidders have already gone through background checks, perhaps we wouldn't have to allocate the entire 171. But that might be, potentially a conservative figure if we have a great number of applicants. It gives the commission at least 90 days to evaluate proposals after the application. That might need to be modified based on Director Day's analysis, but we could figure that into our planning process. Potentially, what we could do is move the October application date a little bit earlier. So this process, it anticipates an award by December 2014, consistent with our earlier plan, even if there are surrounding community disputes under the map that we've created here. And a couple other benefits of this schedule is that it provides existing bidders an opportunity to apply in the event of a rejected referendum before October 3rd. So if you have an October 3rd deadline for us, then potentially any bidders that failed in a referendum could then become part of the mix, ensuring more competition for Region C. And then this schedule also gives time for the commissioner, gives the commission the benefit of being able to evaluate any progress made on the Region C travel gaming application by the time of the award.
Comments, thoughts?
Well, my first thought was that we were taking too much time for this, that there is that consistent concern out there that letting the region fall this far behind and the others are up and running and establishing loyalty. So that was something that I thought made some sense, that kind of a comment. That was just my one thought, that we could probably do this sooner than this time frame.
Others?
Well, along those lines, there are, specifically some things that we could look at right now. I think we've learned a lot in terms of duration and some of these. What needs to happen, especially that we don't control, surrounding community agreements, let's say. But the pieces that we do control, for example, the publishing of the RFA as a first activity, could we publish that earlier than what's currently projected here, as in the late of June, the last days of June?
What has to be changed in the RFA besides, a few dates and stuff? Is there any material?
No, not much. The newly created, if it's adopted, site designation policy would need to be included in that. But beyond that, there's not that much that would need to be amended.
I don't see why, I agree, I can agree with Commissioner Zuniga and Commissioner Cameron. It seems to me like we could, in gross terms, we could pick up a month. Well, a very important date is when they have to put up their 400,000. That's a really critical date. And to me, the primary consideration is giving enough time for entities that didn't know they were going to be able to bid to get together a proposal. And that's very important to our whole competitive shtick. So what's enough time to give them a chance to get organized? Basically, the schedule now gives them 6 months from the time we voted to open C to the time they have to put up their 400,000. I think we could easily take a month off that and not compromise anybody. I don't know that we could take much more than that, but I think we could pick up 1 month, and, start at September 1st. And then in the investigations, this is basically the same period of time that we put out for the investigations. It's 6 months, which is what we had for the investigations when we had 11 of them. So I don't know why we couldn't take that down by a couple of months.
Yeah, perhaps it could be joined by Director Wells, but I raised 2 points. The October application date was, one of the primary reasons for that recommendation was to not interfere with our suitability determinations, which will be ongoing during the month of September. And what we are hoping to do is do a little bit more of the work on the qualifier scoping meetings ourselves in that run up to the application date. And if we moved the application date from October of this year to September, it would be right in the middle of our determinations of suitability for A and B.
Those determinations, go ahead.
I had the same point. I actually did not anticipate most of them waiting till September for those suitability.
Well, so my expectation is that, we'll probably do Region A, then Region B potentially. We'll see how the reports come out. A lot of this is dependent upon whether or not there are findings which the applicant is going to object to. If I get reports, I'm expecting some reports at the end of July, potentially 1 or 2 maybe at the beginning of August. If those, I would then review those reports, submit them to the commission, the applicant gets them, there's then the process. If there is a contested issue on that, then I will be heavily involved in that hearings process if we do that. So if that is the case, that will go probably into September. So the concern is, do you want to start this background investigation part when the IEB is involved in that process? We may not be involved in that process, so there's that unknown factor.
But the IEB would be complete with their work. You may be involved with the hearing.
I would,
But the
yes.
IEB investigators would be available.
Yeah, and the consultant investigator, state police, although I would expect that as part of the hearings process, it's like trial prep, so there would be involved with potential witnesses and preparing and getting that up to speed, so there's that component of it.
I'm actually less concerned with the time, the duration of that background investigation, because that doesn't drive the schedule. What drives the schedule is the amount of, because there's float here at the end of that. What drives the schedule here, at least as represented here, is the time and duration we've given to the host and surrounding communities, which we should talk about, especially because if we have a site determination early on that we didn't last time around, that could really have a positive impact into the surrounding community process, one that could shorten the duration. So that's something that that would shorten this duration, which is what is currently driving the critical path in this schedule here.
You could consider moving up the site determination date by a month, in that basically puts communities on notice of where these sites are, starting theoretically the negotiation phase.
But even if we didn't move it, the fact that we are now explicitly saying this is a deadline for site determination, in my view, that very fact could really be helpful for the surrounding community
It will,
process. Because
yes.
now they know officially. Now they know that they have to be reaching out or not to an applicant and vice versa.
But I would think, I like the idea of moving it up a month as well.
That
There's no
could work
reason
too.
why we've been doing this for some time now. Folks have been paying attention, they kind of know what to expect, and I think can be prepared to move this.
I think in the end, this all comes down to a balance of, if this is ultimately very aggressive, then we may be decreasing the chance of competition, which I know we also want to.
Well, the only difference, the only issue that affects the amount of competition is the 400,000.
The deadline.
Is the 400,000 date.
This
After-
deadline.
Right, but that's, the other ones don't matter, how long we take Once they're in, so.
That's a good point.
And
But
I,
on the competition piece, maybe I'm just restating the obvious. Both the 10-4 date and a month earlier are going to eliminate potential competitors. It's going to eliminate all the people that don't get selected in Region 1 and Region 2. Waiting for them is going to push this way back, so we probably can't do that. It's going to eliminate people who lose the host community votes if those community votes haven't been taken by that time. We're basically, this schedule basically says, with one possible exception that comes to mind, we're going to be looking for new people, not people who are already in the game. I mean, that's the consequence of this, right?
which is what would have been the case if we'd been able to do
It may be. I would just want to
Yeah.
make sure we don't overlook.
Well, part of the comment is that the month of October was also chosen because it'll be after the referendum votes for a good number of the applicants. So potentially they could get an application very, very quickly. But I think you're right, that.
Well, with the following sort of caveat, if there's current competitors who lose in Region A or B by a failure of a host community agreement referendum, they've already paid the $400,000 on Region B or A. So this deadline, in effect, is less dramatic, let's say, for those applicants.
Well, that's an interesting
Oh,
point.
that's interesting.
I
Yeah.
know.
Should we make the decision that if you are already an applicant for A and B, and prior to some critical point here, lose out on A or B, that you may automatically become, obviously you don't need to pay another $400,000.
And
You will have
suitability is
concluded.
complete.
Suitability is complete.
You can just go right to the RFA2 process,
go right to-
provided you
To find a
disclose the
community.
date,
Well, you would
I
still
mean,
have
the
to be
place.
determining the site.
the site. You could
So-
go right to the site, though.
That would be the critical deadline for them.
Right.
And would you also include slots? And if someone, for whatever reason, that didn't work out on a slots application, would they also be in that pool, not just Region A?
They
and
paid the
Region B?
$400,000 and had suitability as well.
I would say, yeah. But I hadn't thought about that.
But not for another slots program.
No,
Right.
it would
Oh,
have
no,
to be for.
that deadline is gone.
Correct.
It's gone. But that's right, that's interesting.
Yeah.
They could go right to the
Right.
site designation and
Mhm.
move on. They wouldn't have to file a new RFA1 application, basically.
Right.
They would likely have some new qualifiers.
Right.
Yeah,
Which we would-
modified.
Yep.
Well,
That makes it-
yeah, that's a really good point, and I think that really enhances the competitive situation tremendously, and I think that's a policy decision we absolutely should make. I still think that the idea, for the most part, your team, your consultants and staff will be done. I mean, there might be some going on, but for the most part, compared to what they've been going through the 6 months prior, they'll be done. And in the interest of getting these folks, the Region C folks, going, I would strongly suggest that we take 1 month out of the pre-RFA 2, and back it up to September. Pick up a month there, and then find another couple of months, whether it's in the number of months that we assign for the investigations, or whatever, so that we move this deadline back a total of 90 days.
Final deadline.
The final deadline.
Award deadline.
The award deadline, right.
I agree, I think that's
Yeah, I
doable.
think that'd be good.
Mr. Chairman, just a couple of suggestions while we're talking about it, we had an RFA 2 deadline of 9/3. Potentially, that could be moved forward.
RFA 2
Deadline of 9/3/2014.
Right, 9/2, but yes.
Phase 2 implications.
9/2.
Yeah.
Perhaps that could be moved, that potentially, we could look at that month as a time to move things forward.
Right, there's a variety of places in there
Yeah.
where you could pick up 2 months, I think. But I think we should do that. We should try to
And,
do that.
but we do have the 90-day of staff review, which is inconsistent with what we talked about now. Well, for 70, Director Day referenced 70 total days for staff review. We have 90 days here for staff review, or commission review of the licenses after the applications. So it's a little bit more than the 70 days, but these are Category 1 facilities. So that 90 days may be realistic. But some of the comments that we've received would indicate that the 90 days would be too short based on the number of hearings we would require, et cetera, et cetera, et cetera. But potentially this, as we get into the Category 1 schedule review, we can also take a look at this particular number, the 90-day number, because they would be entirely consistent.
Right.
Or mostly consistent.
Right. So one of the things, we've decided on two things, I think. One is that we have a process for letting losers in A and B become
Do we want to really call them that?
losers, non-winners, whatever.
Those who were not
non-licensed.
selected for the one
Yeah,
license.
okay.
Well, even those who want to hedge their bets, if they want to jump into that pool,
Right.
hedging their bets, they're free to do it, and they would have to only actually take some action by 12/1,
Well,
right?
12/31.
yeah, well, let's talk about
Yeah.
that site designation thing. You know, we have said we will conduct the Region C process, well, we said that we would conduct the evaluation as identical criteria to
Evaluation.
A and B. Is that, why would we put in a requirement that they designate a site when we didn't do it in A and B? I mean, I understand that it conveniences us a little. I mean, for the most part, the weird situation with Cordish is highly unusual. I think we all agree. Everybody, except for Cordish, has had a site selected for months. So the likelihood that we're gonna need to force them to pick a site is very unlikely. But if, like, there's an outlier, like Cordish was this time, and they wanna wait, and we decide it's all right, then we let them wait. And by not having a site date, that gives all the more time to the non-winners from A and B and the slots. That's the one thing where they will be under the guns trying to find a site. But if we take that away, that gives maximum opportunity for them to try to find a site. So in all of those contexts, why force everybody to identify a site?
I
Go ahead, please.
I think we'll probably end up saying the same thing. It was somewhat problematic for investigations, because are there going to be more qualifiers? What, you know, how does this work with the land and those individuals? So that, I think, was somewhat, made it a little more difficult in finalizing qualifiers and really understanding the scope of the investigation.
I would agree with Commissioner Cameron. Cordish worked around that because what they had set up is they'd be buying it outright. So
Right.
it wasn't an issue where there'd be more qualifiers, but if another applicant set up a land deal where there was some kind of
Speak up.
percentage,
Speak up
where
to
there
the-
was some kind of percentage interest, then that becomes more problematic in identifying those qualifiers and who we would.
It's the little one, not the big one.
Oh, okay. Who they
No,
would.
I forget, which mic is it? I forget.
Oh, this one's green.
Both, all right. Both mics, move them
So,
over.
there is advantage. We can obviously work with applicants, and, we did that with Cordish, and they were responsive, and we kept in contact with them going along, but it is easier for me
Right.
if I have a set date and they know what the site is.
But here, these people the people we're talking about will all have completed, at least if they're,
Most of them.
most of them will have completed a suitability investigation, and the new qualifiers may have something to do with the site, but it won't be the main body of new people.
Correct, and that may be a determination for the commission. If the commission is comfortable, somewhat like financial sources being identified later in the process and then being screened, and if they're not acceptable, they cannot be involved in the process. You could theoretically do that with the land deal. My understanding was the commission was sort of uncomfortable with that when we
Well, we
discussed that
kept,
with Cordish.
I think, we kept deferring, I think, to your judgment on this. We were ready to put a dedeline down to say,
Yeah.
hey, you gotta identify.
Yeah.
Until you two really would say to us, it's okay, and they're getting there, and we're
Yeah.
all right. And I think we should do it the way we did before, which is, if they haven't identified a site, if it becomes a problem for us, we say, all right, you gotta identify a site. And if you need to put your foot down and say, you gotta do it, then you do it, and we'll follow your lead on that, rather than pick an arbitrary.
Right, I think that we, just in the interest of fairness to applicants, we would need to give some lead time for that, and so that they expect that that may be coming in a reasonable amount of time, just for business practices.
Putting your foot down?
Correct.
Yeah. Well, we'll be talking with
Yep.
these folks, and again, it's a weird situation where you don't identify the site. I mean, and people who didn't identify the site realized they made a mistake, I'd say.
Mhm.
Everybody's gonna, with the exception of the people who are already qualified, everybody is gonna know their sites by then, it's almost certain.
Well, and, you know, identifying the site has two implications that I can think of, major implications. One is, of course, the determination of suitability and the partners or the qualifiers who may or may not be, but also the local process, the host and surrounding community process. So if this extends, let's say, because there's no deadline for site determination, then our desire and current reg of not putting something in referendum until applicants have been found suitable starts to run against, you know, the rest of the timeline here. So, but for that, we have an exception that Everett and Springfield took advantage of. And, you know, others may be able to do that as well.
The primary reason why I recommended this, both from the qualifier angle, but really because of the impact on communities. There were a couple of applicants that didn't have a site for quite some time, and a number of different communities are facing, you know, some very tight timeframes in trying to determine what those local impacts are, and then, you know, by the general rule that you can't have surrounding community agreements until you have a host community agreement, that leaves a lot of pressure to those surrounding communities.
But we'll be following your lead on this.
Yeah.
Doing it this way changes the rules, you know, in a way that I don't think we have to. I think you guys can tell us when the process is going along. If you need to have a decision made for whatever reason, background checks or surrounding communities, you'll tell us, and we'll say it's time. But rather than pick an arbitrary, and that's what happened last time. You guys kept saying it was all right, so we said, okay, but you'll tell us next time. Rather than, I mean, setting an arbitrary date, unless there was a really compelling reason, changes the rules of the road just a little, and I don't see any reason to do that.
And I'm not trying to be argumentative, but
That's okay.
the final point is that part of the reason why we were trying to provide flexibility is that our regulations didn't contemplate an earlier deadline for designation of site. And so general issues of whether or not we're at the compliance with the regulations, that was raised as an issue. And I think that was part of our flexibility on that.
Right. You know, I don't think it's a huge issue, but I've stated my opinions. I mean, I'm happy to do what everybody else wants to do.
I think we can take care of that issue by modifying regulations. We've got a third round of regulations that we have to promulgate to get things up and running. We'll have an opportunity at that, and that's got to be done soon, not tomorrow, but soon. And we'll have an opportunity to update existing regulations, and we can put people on notice that for future license applications, we may require a designation date, and on X number of days' notice, for example, so that we cover ourselves that way in terms of the fair notice. So there's a way to deal with that. At the same time, we take out a hard and fast deadline as well, and then make that designation a functional one. I mean, that determination a functional one.
Everybody okay with that?
Yep. Full agree.
It seems to me that we should probably articulate the very big decision we just made about letting non-winners become applicants in the way we've described. That's a very big deal. So does somebody want to frame that as do you want to try to frame that as a motion?
Yes, it ought to be embodied ultimately in a regulation as well. We ought to modify slightly our regulations, and we can do that as we move down the line. But I'd move that the commission allow any applicant for a Category 1 license in Region C who has concluded favorably the suitability process with regard to an application for Region A or B.
Or slots.
Or slots, be permitted to file an RFA 1 supplemental application and an RFA 2 application in Region C without paying an initial $400,000 application fee, but be nonetheless required to pay any additional expenses required for a supplemental suitability investigation with respect to the Region C application.
Second?
Well said, yeah,
Just
thank
for
you.
a discussion of that, I think what we talked about is, with Enrique's point, was we're now saying September 2nd would be the date that the RFA 1s would be due. We're saying, I think we meant that we would consider supplemental background RFA 1 information from previously, from non-winners, later than September 2nd. We would treat that as a, partial changer of qualifiers, not as a whole new RFA 1.
Application, yeah.
So it would permit them to come in, basically, whenever they decided they were gonna do this, they could come in and we would have to go over, we would be modifying qualifiers, not taking a fresh new RFA 1 with a deadline.
I'd prefer to put that in a separate motion, because if we go back and try and amend the
Okay,
motion
well, I
that
was
was just made.
That's fine. I was just talking to make sure I understood what we were saying. But is that,
Right.
but that is what we
Right.
intended, right? That was the
Right.
whole point of Enrique's
Right.
observation.
Right.
Among others.
Okay.
So,
Yeah.
I second that motion.
okay.
As
The
amended?
original, the
there
original
is no
motion.
amendment. There is no amendment.
All right.
We'll have a separate motion.
Well, could we just clarify it in the text that you did and you meant what I asked?
No.
Okay. All right. Any further discussion? Shut up, Crosby. Is there any further discussion? All in favor of the amendment as initially read and not amended? I mean,
The motion.
Okay. Please say aye.
Aye.
All opposed?
Okay.
The ayes have it unanimously.
Now, I could make a second motion that applicants who have filed a Phase 1 application in Region A or B, and, or for a slots parlor, and who have received a favorable background investigation report, be permitted in Region C to file an application at a date the commission sets that is later than the date applicable for Phase 1 applications by those who have not participated in an application in Regions A, B, or for a slots parlor.
So that would, second?
Second.
So that would enable us to, at our will,
Set a
say
date.
to somebody, okay,
Right.
yeah, you've decided, you're fine, well, you've got to submit the extra people, but, yeah, okay.
But, and you have a later application date.
RFA 1 application date.
A RFA 1 application.
Does that work, everybody? Any of the 400 lawyers in the room want to say anything about that?
Yeah, I guess my only concern is if there are changes, that there is enough time for suitability. So I have, that date of here on 1/21, so they would have to submit it before then. But if that gives a 2-month date between.
But we're not setting dates now. We can
Okay.
take all that into account in a functional
Yes.
way and set a deadline. All we're doing now is saying that it doesn't have to be
Oh, okay.
the deadline
The
that's
first
applicable
deadline.
to other
Okay,
people.
we'll work that.
Because they have in effect already complied with a deadline, the
Right.
one for Region A and B, because they submitted their applications,
Okay.
were found suitable.
And we're basically, I think we've agreed that we basically accept changes in qualifiers almost on a real-time basis. That could go on. So if it were a macro change, that would be a problem, but if
Yeah,
it's.
I guess I'm just trying to anticipate
Yeah.
something we may be dealing with later, if there's a significant change. So some of these entities have, multiple partners.
Yeah.
So what if half the partners want to do this under that same entity and half of them drop out? There could be that, so
Yeah.
let's just
So
be
you
aware.
would like us to set a date certain at some point?
Correct.
Right.
Yeah. Okay. Any further discussion on this motion? All in favor? Aye.
Aye.
Opposed? The ayes have it unanimously. Should we vote to adopt this schedule? It seems to me that's pretty important, too. The amendments of moving the RFA 1 date back to the first of, give or take, the 1st of September.
First
and-
of June. Oh, yes, I'm sorry.
First of
Yes.
September.
Yes.
And shortening the award date by 2 other further months from various places in here to be done by you, by the staff.
Would it make sense, Mr. Chairman, to wait to our next meeting so we can look at the RFA, at the Category 1 process for Regions A and B, and this at the same time, and come back with a consolidated plan? It's only 2 weeks away, and it seems to me we benefit from actually having a Region C. We have the gross outlines of it now, but a Region C plan that we could actually approve and say this is it.
I would be in favor of that. Plus, there's fine tuning that we need to do on the master schedule anyway.
Right.
So
Okay.
I would be in favor of that.
Fine. So that will be the 30th, right?
All right.
Okay. Director Wells, how long is your?
I'm pretty brief, so.
Okay, well, maybe.
Could I just say
Yes,
one
sorry.
thing before we leave this area? And this was prompted, I talked to Director Driscoll about this yesterday. The Regency issues about why we were proceeding and how we were proceeding in Region C were addressed, and I think put to bed in the blog that you posted on the website. Something else, though, cropped up in the reports of the hearings yesterday, and that is the exclusivity piece. And it's important, as we discuss this, to recognize that nothing we're doing today changes anything about the tribe's ability to pursue the tribal permits, nor does it change the exclusivity provisions of the compact that's now being debated by the legislature. Because the exclusivity, for purposes of calculating the amount under the compact that's payable, turns on when and if a commercial slots parlor or a commercial licensee starts operating. Not on anything we've done thus far, not even on our award of a license to anybody. It's the commencement of operations that triggers and affects the payment scheme. So that's another subtlety that I think, in reading some of the reports that I looked at yesterday, is not fully comprehended by everybody. And it ought to be, because we really are dedicated to not interfering with anything the tribe is doing as they move forward.
Agreed. Let me get well, no, let's go ahead and do you,
Okay.
and then I'm going to talk about this afternoon.
I just have on my agenda here the confidential information procedure. I think it's Lee Conroy, I think is present, and mentioned a concern about the confidential nature of supplemental documents that are being requested for the investigations that are proceeding. So I just wanted to publicly sort of outline specifically 3 points. One is, if there is a public records request for this information, I don't know if there will be or not, and in what capacity, we'll deal with that, on an individual case-by-case basis. But should there be an individual public records request, notice will be given to the applicants and an opportunity, to be heard on the legal parameters of what can and cannot be disclosed in those public records requests. The second point is that the exemptions to public records law, that applies to these supplemental document requests, just like they apply to the initial applications. Gaming Legal outlined these general provisions in a letter that was sent out to the applicants that had requested additional redactions, and Attorney Satnoff had done an excellent job with those legal parameters. So I believe those applicants have that sort of outline. But just, to publicly address that issue, for example, private information such as personal bank account information or trust information with respect to minors, those things are subject to exemptions, and those would not be disclosed if there were a public records request for that. Additionally, there's a specific exemption for trade secrets, or information that would put the applicant at a competitive disadvantage in the industry. So, my third point is that there should be an expectation that a significant portion of this information would be deemed confidential based on the nature of the inquiries that we're making as a result of these investigations. So I just want to make sure that, managing the expectations of both the applicant and the public, that these are personal, there's personal information that's being obtained, and there's a lot of information, confidential, financial information that pertains to corporations and would pertain to their trade secrets and their competitive nature in the business. So just want to outline that for anyone that may be concerned about that, and if there's any questions by the commissioners, I'm happy to address that.
Has that decision satisfied people that were concerned about something else?
If I get calls that we talk about it on an ongoing basis, I do respect that there is concern out there. Ultimately, any determination we make will go through legal. There will be, a process, and then if there's any information that's not private that could be disclosed, that will happen. And then if there is an appeal, if someone who's requesting the information doesn't like what the commission does, they have the ability to appeal to the Secretary of State, and that would be the final arbiter on that decision. But based on the nature of the information that we're getting, my expectation is that as we pare through it, a very limited amount would be disclosed.
Okay. There have been 2 of our 11 initial bidders have come a cropper. Are we still doing background checks for Penn National? And
yes, I've been in contact with the attorney for Penn National and did receive a request in writing to continue with, he set some specific entities and qualifiers and requested that suitability investigation continue. So we have addressed that, and I also had a conversation with representative from the Cordish entity, also requesting that go forward. That's basically done, and I expect an initial draft report probably today,
Okay.
if not tomorrow. So that's
Okay.
basically completed. We'll just go through the process of reviewing and any changes we need to the report before it goes to the commission and the applicant. That was one other issue I wanted to address with the commission that's not on the agenda. I've been assured by the representative from Cordish that they are continuing to pursue this Category 2 slots license, and there are other sites they are looking at. And they are representing, they do not anticipate additional qualifiers involved in the process if they locate an additional site that have the same kind of deal that they would have had in that Boxborough issue. So that seems to satisfy that issue. We can just proceed accordingly and see what happens with their plans.
Great.
Okay.
Okay.
Thank you. Before we conclude for lunch, I think Director Dernberger probably has a very short report also. I'm wondering
Okay.
if we could do that before.
Sure. Director Dernberger? Thank you very much, Karen and John.
Thank you both.
Thank you both.
Great stuff. Item number 8, racing.
Good afternoon.
Good afternoon.
Mr. Chairman, Commissioners. Mr. Chair, would I be able to have a guest join me at the table?
Sure.
President Nowak, would you like to join us? This is Mr. Ed Nowak. It's my pleasure, actually, to introduce him on this basis to the Commission. This is one of your key stakeholders. Mr. Novak is a standard-bred horseman, breeder, owner, horse shower, ringmaster, horn blower, and most relevant for the purposes of this conversation, he is the president of the Standard-Bred Owners of Massachusetts.
Great.
So I'd like to introduce him.
Welcome.
Thank you.
Welcome. What's
Thank
the
you.
hornblower part?
Trumpet. I play a fanfare trumpet at Plain Ridge. And, yeah, that's it.
Sounds like we have competition now.
No, that's a great sign. That's great.
I'd like to see how that translates in the transcript.
Commissioner Toots.
Toots his own horn.
Right.
This actually serves as an introduction today to the agricultural statute, Chapter 128, which is different in a lot of states. The Racing Commission or the Racing and Gaming Commission manages this part of a breeders program, but in the Commonwealth, it does appear under the agriculture statute. However, there are bits and pieces that interact with your role as the Gaming Commission, and one of them is to approve a representative group that comes forward and requests approval to represent, in this case, the standard-bred folks in the Commonwealth, to administer a series of sire stakes programs as well as the mass-bred breeders program. And Mr. Novak is here to answer any questions or even maybe describe it in a little bit more detail than we did in the memo.
Are there any questions first? We've been the organization that has been appointed annually through the then Mass State Racing Commission to administer the breeding of standardbreds in Massachusetts and the sire stake races program. We've been doing that now since 1992, and I've been president of the organization since 2007. And the program is working, and we're going forward and putting together our racing dates for this year, for 2007, which will be in the fall, 2013, and would like to be reappointed as the governing body of this organization, of the breeding and standardbred sire stakes racing.
So how this works is it provides an incentive to folks to breed their horses in Massachusetts, and there's carefully delineated processes by which the horses can be declared as Massachusetts bred and then are therefore eligible for this series of races and also breeders' awards. So that's the interaction with racing.
We have approximately 75 members, active breeders, and another 200-plus members who have shown and indicated to us an interest in breeding standardbreds in Massachusetts as we go forward.
There are how many breeders now here in Massachusetts?
75.
75.
Right.
Just standardbred.
It's just standardbreds.
Wow.
Now, does anybody breed standardbreds and thoroughbreds, or is it?
No, it's, you take your pick. You're either a
One or the
standardbred
other.
person or a thoroughbred.
I see.
Yeah.
And another 200 are.
Who have indicated
expressed
interest.
in doing it.
Yeah, in doing it.
And what would be the, how could those people be incentivized to do it?
They would be incentivized if Plain Ridge Racecourse was awarded the slot license.
Or taking it.
I walked into that one, didn't I?
Thank you for that question.
Let's summarize that as increased purse monies.
Yeah. So if
Increase
the money's
expense.
independent of the Plain Ridge issue, the money that comes into the racehorse stabilization fund,
Exactly.
which, that will materially affect these races, I assume,
It
too.
will
right? As well
affect
as
the
your
purses,
other
it will
purses.
affect higher purses, generate more interest, and higher purses create better horses, better
Right.
stock. There's more of an incentive to invest money in the race, in the standardbred racing.
Right, right. 'Cause as I understand it, the money that was coming in to the racehorse stabilization fund, once everything is up and running, which will be a while, pardon?
Racehorse Development Fund.
Race, what'd I say, stabilization,
Stabilization.
yeah. Race development
Which
fund.
is-
That too, yeah, right. This pretty much doubles purses.
Yeah.
That amount of money that
Yeah,
it pretty much
approximately.
doubles purses,
Yeah.
which is, I guess, a pretty big deal.
So, yes, that would be an incentive to get more people to
Right.
maintain open space, breed horses, and which takes a lot of space, time,
Right.
and money.
Right. Great.
considerable amount of time before an owner breeder can have a return on their investment.
Right.
Considerable amount of time.
I should know this, but do standardbreds, when do they start racing?
At what age?
Yeah.
2.
At 2.
Yeah,
So that's essentially the same.
yeah.
Is there anybody else who wants this job?
I haven't heard of anybody.
Okay.
I'm not sure why they would want.
I think we're going to enthusiastically endorse this one.
Yes, I agree.
I agree too.
Somebody want to make a motion?
Sure. So I move that this commission approve the request from the Standardbred owners of Massachusetts to be recognized as a duly organized representative group of Standardbred breeders to administer the Massachusetts Standardbred breeding program.
And sire stake
And sire
races.
stakes.
Second.
Second.
Any more discussion? All in favor?
Aye.
Aye.
Enthusiastically.
Ayes have it.
All right.
It's an enthusiastic endorsement of your
Yes.
proposition.
All right.
Thank you.
Thank you very
Thank
much.
you.
Dominic and
Thanks for coming.
say thank you.
All right.
Okay, you more?
That would conclude my report. I really don't have an administrative update today.
Great.
Okay, great.
Thank you, Director.
Thank you. All right, it's 12:20. I just want to get a sense of expectations about this afternoon. I have a long time scheduled board meeting that I chair at 4 o'clock. They know I might not make it. If I am going to make it, I'd have to leave here at 3:15. So my question is, if we start at, even if we start at 1, Rachel will take at least a half hour, maybe a little more. So we would start, 1:30 to 2, we would start the regs. Are you all prepared and interested in sticking through the afternoon for as long as we can? In which case I will get out of my meeting.
Well,
But
I
if
think
you
we
all-
have to do that. I'm not sure how long it will take. Everybody's had a chance to talk with Mr. Grossman and General Counsel Blue, so if your questions are succinct. I mean, among other considerations.
All right.
Any event, the answer is yes.
Okay, so we do either whatever
Right,
way,
right.
we'll stick with it, okay. Then I suggest that we adjourn for 40 minutes and reassemble at 1 o'clock, and we will start with Dr. Volberg with the research presentation. Okay. Thank you.
Great. Thank you.